this right. The applicants were under no obligation to apply for legal aid to the respondents to provide the same. But the respondent was under an obligation to ensure they were represented. In light of all the above, the court concludes that the applicants were entitled to legal aid and need not have requested for it. The court notes that even though the respondent was aware that the applicant's counsel has abandoned them, the respondent proceeded with the case against them and eventually convicted them without counsel. Having considered all these circumstances, the court finds that the respondent failed to comply with its obligations under the African Charter to provide the applicants with legal representation in respect of criminal case 002 of 2006, for which some of them were eventually convicted and sentenced to 30 years of prison. I'm coming now to the before last part of the judgment, namely reparations. Part 10, reparation. In the application, the applicants request reparations for the violations alleged should the court rule in their favor. The respondent, on the other hand, in its oral submissions at the public hearings, prayed that, I quote, the applicants should not be awarded any reparations with regard to claims and allegations made in this application against the United Republic of Tanzania. Article 27, paragraph 1 of the protocol establishing the court gives the court powers to make orders for reparation. It reads as follows, I quote, if the court finds there has been a violation of human or people's rights, it shall make appropriate orders to remedy the violation, including the payment of a fair compensation or reparation. End of quote. The court decides to provide for some kinds of reparation in the operative part of the present judgment and will decide on the other forms of reparation in a further judgment, taking into consideration the further submissions of the parties in the matter. I'm now coming to the part 11 relating to costs. Both parties to the present case prayed for costs to be borne by the other party. The court notes that Rule 30 of the rules states, I quote, that unless otherwise decided by the court, each party shall bear its own costs. End of quote. The court will rule on this issue in its judgment on the other forms of reparation. I'm now coming to the operative part of the judgment. For all these reasons, the courts unanimously, number one, dismisses the respondents' preliminary objections on the jurisdiction ratione materiae and ratione personae of the court to hear the application. 2. Decides that it has jurisdiction to examine the application. 3. Dismisses the respondent's preliminary objection based on the fact that the application does not comply with the requirement of Rule 34, paragraph 1 of the Rules of Court. 4. Dismisses the respondent's preliminary objection on the admissibility of the application on the ground that it is incompatible with the African Charter and the Constitutive Act of the African Union. 5. The court dismisses the respondent's preliminary objection on the admissibility of the application on the ground that applicants have failed to exhaust local remedies. 6. The court dismisses the respondent's preliminary objection on the admissibility of the application on the ground that application was not filed within a reasonable time. 7. The court decides that the application is admissible. 8. The court holds that there has been a violation of Article 7, Paragraph 1, subparagraph C and D of the Charter by the respondent. 9. The court orders the respondent to provide legal aid to the applicants for the proceedings pending against them in the domestic courts. 10. The court orders the respondent to take all necessary measures within a reasonable time to expedite and finalize all criminal appeals by or against the applicants in the domestic courts. 11. The court orders the respondent to inform the court of the measures taken within 6 months of this judgment. And finally, 12. The court, in accordance with Rule 63 of Rules of Court, directs the applicant to file submissions on the request for other forms of reparation within 30 days thereof, and directs the respondent to reply thereto within 30 days of the receipt of the applicant's submissions. Judgment done at Arusha, this 18 days of March 2006, in the English and French languages, the English text being authoritative. This judgment is signed by Honorable Elsie Thompson, Vice President, Gérard Onyango, Judge, Fatsa Ogeguz, Judge, Duncan Tambala, Judge, Sylvain Auré, Judge, Ben Kyoko, Judge, Rafa Ben Ashur, Judge, Solomi Bossa, Judge, Angelo Matousé, Judge, and Nuhu Diallo, Deputy Registrar. Madam Vice President, I have now completed the reading of this judgment, and I'm now handing you over the floor. Thank you very much for your attention.
Thank you very much, Judge Ogeguz. Parties are to collect copies of the judgment from the registrar of the court. Mr. Registrar, is there anything else?
No, thank you, President. The parties can collect copies of the judgment immediately after the court rises. Thank you.
Court will rise.